Welcome everyone to this session on auditing. The auditing provisions in the Development Act first came in 2005, but they commenced in 2007. A number of things have happened, and we're only just getting into implementing auditing now. The purpose of today's session is to first of all take you through the legislation and then to take you through the auditing process that's being implemented. So there'll be a number of parts to this session. First of all, we'll look at the objectives for it. Then we'll look at a bit of the scene in which auditing is happening at the moment, the legislation, the audit process, and then we'll look at what can happen in terms of some of the outcomes of an audit. The objectives of this session are to first of all provide you with clarity about what to expect in an audit. Then to go through the legislation in some detail that's relevant to undertaking an audit. Next, there will be a walkthrough of the audit process, showing you what is involved in the process and what is expected of private certifiers and building surveyors in councils when they are part of an audit. And lastly, as I said, we will look at some of the outcomes that can result from the audit. Okay, first of all, for setting the scene, we need to understand some things have happened since the audit provisions first went into the legislation. First of all, in 2009, there was a select committee on private certifiers. They made a number of recommendations. One of those said, and I quote, "Auditing should go further than checking the documentation. It should also involve checking the building assessment process to find fundamental errors." A couple of years after that, the Victorian Auditor General issued a report on the Victorian system of auditing. They made some quite scathing remarks, and there's certainly lessons for us to learn. One of those remarks was, additionally, the audits focus almost entirely on administrative matters, while compliance with the more critical safety and technical issues is not systematically addressed. So, how does our legislation measure up? Going through it in some detail now, first of all, the legislation, section 56B of the Act, sets out in subclause 3 a number of purposes for undertaking an audit. The first, 56.3a, is a general provision that enables a check that the building assessment processes and procedures have been undertaken in accordance with the Act and regulations. Now, the provision specifically says, particularly in relation to the regulations, there's an emphasis on what is prescribed in the regulations. The second purpose is described in 56B3b, and that enables technical checks to be undertaken, but at the auditor's discretion. It's noteworthy that, in fact, on technical checks, it is where the auditor thinks that it is appropriate. The third is in 56B3c, and that covers anything else that's prescribed by regulations. Now, the good news is that nothing else is prescribed by regulations, so essentially we're left with the first two as our main purpose for undertaking audits. The Act also provides some provisions on how audits are to be conducted. 56B9 goes into some detail about how the audit is to be conducted. And 56B10, now this is standard audit practice, but nevertheless it's in the legislation. It requires a draft report to be provided to council or a private certifier so that they're able to respond and correct any errors of fact. It then provides a number of provisions that relate to the relationship of audits to the registration authority. Under 56B6, The registration authority can require a private certifier, as a condition of their registration renewal, it can require them to provide evidence of compliance with Section 56B. So it can require evidence of compliance with auditing. And under 56B(7), there is actually provision for the registration authority to cancel a registration if they believe that a matter has not been adequately addressed that came out of an audit. There are then a number of provisions that relate audits to the Minister. And the first of those, under 56B(11), requires the auditor to report to the Minister where there has been any significant contravention of the building rules. The Minister then has a number of options. Under 56B(12), the Minister can make recommendations, provide directions, and, in the case of a private certifier, can disqualify the person. Under 56B(13), the Minister can also require an investigation if the Minister believes that a broader investigation is necessary in a particular circumstance. Continuing on, the Minister under 56B(15) can change a recommendation to a direction. Now, a direction becomes mandatory, and that direction can be to a council or to a private certifier if the Minister is not satisfied with progress. It's noteworthy that under 56B(16), failure to comply with a direction has a fine attached. And lastly, under 56B(18), the Minister is able to issue guidelines for auditing. Well, that's how the legislation is. The first thing we undertook when we started preparing for auditing was to engage a qualified auditor, not a retired policeman, as some other jurisdictions have done. We believed it needed a qualified auditor in order to make sure we were meeting proper auditing standards. That auditor is John Apostle, and he will now take you through the rest of the presentation. John.
Hello everyone, my name is Joan Apostol, and I've actually started with the department in October 2012. Now, when I started, the first thing that was undertaken in relation to the audit was to prepare an audit framework. The audit framework was prepared based on Section 56B of the Act and the standards and principles issued by the Institute of Internal Auditors Australia and the Australian Government Standards on Assurance Engagement. The audit framework actually serves as an internal document to guide the auditor or auditors in the conduct of building rules assessment audit in councils and in private certifiers. Fast forward to 6 months later, 8 councils and 8 private certifiers have been audited. And as part of that, we undertook a 6-month review. So what we've done was to perform an in-house review of the results of the audit and identified lessons learned. We've sought feedback in each of those who have been audited. So 7 out of the 8 private certifiers and councils have provided us positive feedback with their experience in the audit. We've also opened up the audit function to be audited by the department's Audit and Governance Division, who have also made some suggestions as to how we can further improve the audit process. We've also sought a number of Crown Solicitor's Office advice on a number of audit matters. After that, we've revised the audit framework accordingly, and we've asked ABES to provide a feedback as to what they think with the audit framework. After all of that have been consolidated, we've put up the audit framework to the Minister, who then adopted it as his Minister's guidelines in accordance with Section 56B(18) of the Act. Now, there's just a couple of things that are worth noting with the audit framework. Firstly, the audit framework is an internal document for use by the auditor. Its intention is not to publicize it to the industry or to the public in general. Its objective is to ensure that any auditor who does this role or this function conducts the audit in a consistent manner and at a minimum level of standard as required by the Act and the regulations. Now, we've also input some built-in controls with the framework and with the audit process. That includes the review that is undertaken by private certifiers and councils of the draft report before an audit report gets finalized, and also the fact that the audit function is required to be audited by the department's audit and governance on a regular basis. Now, the audit process. The audit process comprises of 3 key phases. The first phase is the planning phase. Now, the planning phase is the phase which I normally call the preparation stage of the audit. This is where initial contact is made with the council or with a private certifier to agree the timing of the audit, and also to obtain information from the council and private certifier about their building rules assessment process. It's also the stage whereby an initial document request list is sent to the council or private certifier to prepare the information required just in time for the field work of the audit. Now, during the planning stage, an audit planning memorandum is also prepared. This is where the scope, approach, and the timing of the audit are formally documented, and it also serves as a formal advice to the council or the private certifier of the impending audit. Next stage is the field work. The field work is actually the groundwork for the audit process itself. This is where detailed work is undertaken. Now, under Section 56B(9) of the Act, a field work comprises of performing walkthroughs of the building rules assessment process. It also comprises of performing review or testing of sample documents and information such as building rules consents granted. It also comprises performing interviews, discussions with relevant personnel from council or with the private certifiers who can provide information about the audit. The key objective of fieldwork is to gather evidence to be able to ascertain a private certifier or a council's compliance in relation to the Act and the regulations. Hence, the auditor will be required to examine or review relevant documents as may be required to be able to achieve that objective. Let me share with you a finding that was raised by the Victorian Auditor General's report on Victoria's building permit system, which was issued in December 2011. You can actually surf this as well. It's available on the net if you like. And I quote, "There are significant gaps in the documentation lodged by building surveyors at councils. This absence of documentary evidence to support assessments provides little assurance that surveyors have carried out their responsibilities effectively and that they are adequately upholding and enforcing building and safety requirements." Now, this is the kind of find that we're trying to avoid here in South Australia. Should an independent body like the South Australian Auditor General perform an audit in a council or of a private certifier or even with the department with regards to any building rules assessment process. Now, the key point to remember is that any regulatory authority in ascertaining compliance with the relevant legislation, they will have to go back with available documentary evidence to be able to ascertain or obtain any comfort or assurance with regards to compliance. So it is important to note that any audit is evidence-based. Now, one of the questions that we've been asked is in relation to some examples of documents or records or tools or any information that councils and private certifiers can consider to be able to demonstrate compliance. Now, there are a number of private certifiers and councils that I've come across who retain varying assessment tools and different documents that suits their practice when it comes to building rules assessment process. Some of these examples include the use of computer application where legislative requirements are checked, internally adopted policies or procedures, which is probably more relevant in councils whereby you've got multiple building staff, or possibly with larger private certifying firms where you've got multiple building staff as well, to ensure consistency in the approach and to ensure that minimum level of standard in the conduct of building rules assessment. Other examples include the use of checklist or check sheets, which is very common. A quality review by an independent person may also be undertaken, whereby someone independent of the building rules assessment process for a building application actually conducts an independent review of what has been assessed by another building surveyor. That can also be considered. Relevant documents being retained, such as formal notifications as an example, or certificates of independent technical experts. Relevant emails and correspondence, such as outstanding information requested from applicants, assessment notes, note to files, and up-to-date forms and templates consistent with legislative requirements. Now, it doesn't necessarily mean that all these documents need to be in place, or all these assessment tools need to be in place. There are various factors that councils and private certifiers may want to consider to be able to assess which assessment tools and what sort of information or documents they need to retain that will suit most their practice. Some factors that may be considered include the technology used, the number of building applications assessed, the number or the size of the practice itself, and other cost-benefit considerations. Now, one of the things that can be undertaken during field work is technical checks. Now, let's just go through some of the key facts pertaining to technical checks. Technical checks involve the review of plans, drawings, and other documentation to ascertain compliance with the relevant technical standard or technical legislation. Now, it's also important to note that technical checks will not be performed for all audits. They will be performed in accordance with Section 56B, 3B of the Act, whereby they will be undertaken at the auditor's discretion. And lastly, technical checks will be triggered by the specific circumstances surrounding a private certifier or council. Now, technical checks may be triggered in one of two ways. Firstly, as part of the field work, or they may be triggered by contextual matters pertaining to the circumstances of a council or a private certifier. If a technical check is initiated during the audit process, more often than not, it will be initiated because the auditor is unable to ascertain the appropriateness of the assessment procedures undertaken by a council or by a private certifier. And as such, conducting technical option may be the only way for an auditor to be able to obtain that assurance or comfort. Now, there are examples when potentially an auditor may be unable to form that conclusion with regards to the assessment procedures undertaken by a council or by a private certifier. Examples are if there are insufficient evidence or documentation relating to the building rules assessment process, or where there are a lack, or where there is a lack rather of documentation supporting the granting of building rules consent. So that raises alarm bells with any auditor about the appropriateness of the assessment procedures undertaken. A lack of established procedures relating to the building rules assessment process. So if it's been identified that it turns out building rules assessment process is patchy, disorganized, haphazard, then that also raises alarm bells with the auditor about the appropriateness of the assessment procedures. Of course, independence and conflict of interest and other practices that undermine the building rules assessment process. So these are examples when a technical check may be triggered as part of the field work. Now, the other possibility is that technical checks may be initiated by the contextual matters specific to the operation of a council or a private certifier. Now, what are examples of this? Examples are if there's been a complaint or a history of complaints made against a private certifier or a council, then that may trigger a technical check. Another one, if there have been high-risk matters identified within the process or activities of a council or a private certifier, that may also trigger a technical check. Examples of these are high-profile developments being assessed by a council or by a private certifier, or innovative sort of buildings that can be subjected or that can be the subject of public scrutiny, then this could trigger potential technical checks as well. Another one is the existence of technical issues such as swimming pool safety, energy efficiency issue, as they may be relevant to the operation or with the applications being assessed by a council or a private certifier. Now, it is important to know that high-risk matters, such as high-profile developments or innovative buildings, may also be identified during the fieldwork itself as the auditor goes through the samples of building applications being reviewed. It is important to remember that these are only examples. It is not possible to be able to encapsulate all the various circumstances that a council or private certifier may be in to enable an initiation of a technical check. Nonetheless, this should provide an indication as to when a technical check may be triggered. And you should be mindful of the fact that if a technical check is going to be undertaken, the council and private certifier will be informed accordingly. Now, who will perform technical checks? Technical checks will be performed by a level 1 building surveyor. If required, expert advice will be sought. Now, in relation to the extent of technical checks, a technical check may not necessarily comprise 100% check of all technical components relating to a building application. The extent of technical check will be driven by what has instigated it in the first place. So if a technical check has been initiated as part of the field work, whereby an auditor or the auditor is unable to form a conclusion about the appropriateness of the assessment procedures undertaken, then the extent of the technical check that will be performed by the building surveyor will be insofar as ascertaining whether there is any issue with the granting of that building rules consent. If, on the other hand, it's been instigated by other circumstances such as complaints, high-risk activities, or a hot technical issue, then the technical check will be limited to the extent of that technical matter that is the subject of the complaint or of that high-risk activity or hot technical issue. So technical checks will not necessarily comprise 100% of all technical checks of all components of a building application. Now, at the conclusion of the field work, there will be a discussion of potential audit issues identified. The objective of this is to eliminate any surprises from the council or from the private certifier's end. It will also enable a council or a private certifier to have a think early on what action plans they are thinking in addressing those issues. After field work, we have the reporting stage. Now, at this stage, a draft report is prepared by the auditor. The draft report will be furnished to the council or to the private certifier to give them the opportunity to correct any error of fact in accordance with Section 56B10 of the Act. Within the reporting stage, action plans to address issues will also be discussed, and accordingly such action plans and the time frame as to when they will be completed will also be included in the audit report. If all else goes well, and upon confirmation of the council or the private certifier, the report will be finalized accordingly. Now, there can be instances whereby the report may be referred to the minister or the registration authority as may be relevant. Now, when is that? Section 56B11 of the Act states that the auditor must report any significant audit findings to the minister. Significant audit findings. Now, as part of the audit process, we use an issue rating table that contains possible ratings of issues which range from significant to low priority. Now, significant audit findings for the purpose of this presentation includes or are those that represents a breach of the act or regulations that poses a threat to public health or safety, or those issues whereby there is a gross misrepresentation or negligence in the conduct of work of a council or of a private certifier. Now, bear in mind that when a council or a private certifier reviews a draft report, the issues in the report will already have these issue ratings. So in that way, council and private certifier are also given the opportunity to review such ratings in the audit report. The audit process is finished at that point in time when a report is finalized. And if relevant, if it's been furnished to the minister or to the registration authority. Any action undertaken, any possible action undertaken by the minister or by the registration authorities outside of the audit process. In addition to that, the auditor doesn't have any role on that process anymore. And I'd like to call Don back to take you through that process.
Thank you, John. Now, as John said, the audit report has been finalised and it's moved on. So we're now into an entirely different process from the audit process. The audit report is of interest to both the Minister and the Registration Authority. As previously discussed, the Minister can do a number of things: issue recommendations, give directions, change recommendations to directions and disqualify people. The Minister can also appoint an investigation officer to undertake an investigation if the Minister thinks that's appropriate. In terms of the Registration Authority, as we've already seen, the Registration Authority can require, as a condition of registration renewal, that there be some evidence provided of compliance with the auditing provisions. That means that private certifiers need to be ready to provide a progress report on any actions that they've undertaking that have arisen out of an audit report. Now, with both of these provisions, it's important to see them in the context of the rest of the regulations, the rest of the legislative provisions. There are provisions in the Act for Natural Justice, Section 45A of the Act and Regulation 93A are both relevant here. But there are other provisions, so either explicitly or implicitly implied, there are provisions of natural justice that need to be implemented. The first of those is that if there is an issue by either the Minister or the Registration Authority, you must be given the opportunity to make a submission on that issue. So the first thing would be you would be advised that there is an issue and you would be invited to make a submission. If the Minister or the Registration Authority are then still not happy with the response and are considering taking some further action, then you need to be provided with advice on what that proposed action is and be afforded the opportunity of making a submission on that proposed action. So those are things that must happen before any disciplinary action of any sort is undertaken. This concludes our presentation for today. It's important to note that there is information available on our website. We've provided information there that arise out of the pilot audits. So the examples that you see there are examples that building surveyors and councils are using right now. The other thing to note is that we will be issuing a guideline for building surveyors on auditing. That guideline is in the process of being completed right now, and that's been developed in conjunction with the ARBS for practitioners so that you have some familiarity, you have a reference that you can go to if you have any problems, and of course if you need to contact us, by all means contact the building unit or the auditor directly yourself. Thank you.